we were our paper was non-suited last week, sir. And then you advised that
I didn't say we are going
we
to go
revised
back
it,
to
sir.
it now. I've already run over what I expected you to see.
Yes, sir. Yes, sir.
I will just assess your represented seminar paper. It's all right.
Thank you, sir.
I don't like talking about a topic when I have set questions. The tendency is for me to emphasize only what I have said, but I'm going to try to be I'm going to try to cover all grounds on enforcement of foreign judgment within the so-called 1 hour that I said I would take. Now, from the presentation and from what you would have read in the articles cited by the presenters, the first thing to know is that enforcement of judgment or foreign judgment is a course of action on its own. That's the very first thing I would say. It's a course of action. So when you are talking about subject matter jurisdiction, I'm usually shocked at the type of argument that lawyers put up. You have like we know in these subjects, it is your own rules of enforcement or your rules of recognition and enforcement that you will apply when people apply to you to recognize and enforce judgment they obtain in another country. So that gives you the right to regulate how it is to be done. Okay? And your statute provides that your statute provides that foreign judgment will only be enforced in your high courts and define the high court to be either a state high court or a federal high court. Okay? But you will find lawyers, very senior lawyers, and because they are senior lawyers, the judges, I don't know whether they are timid or they listen to them just because they don't even know what the whole thing is about. You find them saying, even though the statute said state and federal high courts, you must now go back to the original course of action that was submitted in the foreign country and determine which court between the two states, the two high courts, would have entertained that case if it was submitted here. So when the statute said high court will mean either state or federal high court, they will now impose their own construction to mean that the statute is saying federal high court if what was submitted abroad, in respect of which judgment was given, was a matter that would have gone to federal high court originally, or state high court if it was a matter that would have gone to state high court originally. And I then fought their logic. If it was a matter that would have gone to National Industrial Court originally, how do you determine who goes? Given that the statute has limited enforcement to the high courts, do you ignore the statute? The logic is strange to me. Everywhere you go to, and the lawyers, they make elementary errors. That type of argument ought not to have come from somebody who understood that enforcement of foreign judgment is a cause of action on its own. And that when you want to enforce a foreign judgment in a forum, it is the rules of recognition and enforcement of that forum that will matter. So there will be no difference between cases that originally could have been instituted here and cases that could have been instituted elsewhere. There is no difference between a case, the fact of which occurred in Kenya, but judgment was given in UK. But the judgment creditor pursues the judgment debtor to Nigeria where he has assets. There is no difference between it and the case that originated from Nigeria, because in enforcement of foreign judgment, you are cutting off the stories. You are treating the judgment as res judicata. Okay? That is one first thing to be known. That so all those stories about if in Nigeria it is Federal High Court that will have jurisdiction in company matter. Therefore, State High Court cannot be required to register a foreign. That is, for me, it's one type of argument that whenever I listen to it, I just shake my head. Say maybe the person should be taught about the subject entirely. Now, in enforcing a judgment, you do not submit to the court the original cause of action. Even at common law, where you say you are suing upon the judgment, you are not suing upon the original cause of action. So, what do you need the expertise of the respective court that would have entertained the original cause of action for? For you to put up the argument that when the statute says you can go to either state or federal court, it is the one that would have entertained the matter if the case had been instituted in Nigeria. It's a clear display of not understanding what enforcement of foreign judgment is. The proper thing is that the enforcement of foreign judgment is a cause of action on its own. And because you are seeking to enforce it here, we have the power to regulate how the mode and the substance and the procedure. And we have stated here that go to our high court, whether state or federal. That is the end of the matter. I ask us as lawyers, when the fundamental human rights enforcement rules, when they were made, and the rules provide that you can go to any high court, and the high court means federal or state high court. I have not listened to an argument that, oh, if you want to enforce fundamental human rights, or in respect of violation by federal agency, you must go to federal court. Or in respect of violation by state agency, you must go to state high court. I don't know if there have been any cases that will say you can't go to state high court because the original cause of action would have been a federal court cause of action. If it amounts to enforcement of fundamental human rights as prescribed by the Constitution, then any of the two high courts that you go to will be all right, because that's what the rules itself says. Okay? But more importantly, if you understand the meaning of enforcement of judgment, you won't even start that argument at all. You will not start it. So I start with the theories. If you understand the theories, especially the theory of obligation, you will see that that argument is inconsistent with any of the theory. The theory of obligation simply says that the reason why we here The reason why we here, we allow the judgment you have obtained abroad to be enforced here is because we are treating the judgment as a debt, as our own recognized debt. And we are therefore qualified to insist on the requirement for recognizing that debt as a debt. Okay? And that is why you find whether at common law or statute or under registration regime, you find that it's not automatic. We impose conditions, the most important of which is we want to be sure of how the foreign court exercise jurisdiction over you. And when we are talking about jurisdiction in that sense, we are talking about jurisdiction in the territorial or international sense. So you find the requirement emphasizing what gave the foreign court authority over you. And so whether at common law or under statute, or you have principal place of office there, or it was possible to serve the writ on you there, or you voluntarily submit, our court to say, well, we can go ahead to recognize this judgment. In all of those questions, nobody is asking issue of whether Nigerian law was properly applied. Our requirement very basically is that what authority did that territory have over the judgment debtor? That's the whole idea of the concept of obligation. If a case was decided abroad, but the judgment debtor was not dragged there, so to say. When I use the word dragged, I mean it had nothing to do with the place. The judgment creditor just arbitrarily made a choice of a place where he knew he was going to be helped. The man was then served. You will see cases where somebody will be in his own country. Okay? The other party will drag him to another country. Okay? And the court of that country would authorize the service of court process or notice of it on him wherever he is. Now, you know that when we are treating jurisdiction, we call that assumed jurisdiction. And we look at a number of localization factors. Some of them include the presence of the rest. Some of them include that the tort occurred there. Some of them include that the agent who entered into contract on behalf of the parties lived here. Now, all of these localization factors, many of them will not meet the requirement of residence. They will not meet the requirement of having principal place of business. They will not meet the requirement of voluntary submission. But we have stated them in our own assumed jurisdiction rule as a basis upon which we can allow notice of writ to be served on somebody. So, in several cases that you will come across in this area, I can't remember cases now. The issue has been, look, they want to enforce judgment in our territory. Our only complaint is that they use a method we also use to drag our resident defendant, now judgment debtor. Why should we not register the judgment? Why should we not enforce the judgment? They have not done anything more than what we ourselves would do. The English got to say no, no. Even when we ourselves would do it, we knew that what we are asserting is, quote and unquote, exorbitant jurisdiction. Exorbitant jurisdiction. And we are not thereby saying that we accept it to be asserted as a basic. Because
Yes. Hello, sir. You are muted, sir.
Prof, you are muted, sir.
does it mean you people have not been hearing me since?
Yes, sir, we're not hearing you.
Oh. You have never heard me since I started.
No, Prof, we were hearing you, sir.
Just this
It
few
just cut
minutes.
like some few seconds ago, sir. Maybe
Some
like
minutes
30,
ago,
40
sir.
seconds.
Okay, so I was still addressing this issue of saying that they must go to the court that would have entertained the matter, the course of action if it was submitted, if the action was instituted in Nigeria, not in the foreign country where the judgment was obtained. And I am trying to say that the argument is a non-starter. In fact, it should irritate anybody who has a knowledge of this subject area. Okay? It should, and that's what it does to me each time. Even though I know that it is our senior advocates and the judges that keep hammering those things. But to me, it just betrayed their lack of understanding of what enforcement of judgment is all about. Okay? And that's what I'm trying to explain. That the reason why we enforce foreign judgment, the reason why we enforce foreign judgment is explained by theories. And we have obligation, we have committee. Obligation is simply saying we are giving conditionalities in order for us to recognize the judgments, the judgment sum payable as a debt. We want to be sure of certain things. One of them, none of them is that you apply Nigerian law properly or that you apply the law of the country where the cause of action occurred properly. There is none there. If you go through, it's none of them. So nobody is tasking the judge to review whether the law was properly applied. We are only concerned with conditionalities that have to do with territoriality, territorial propriety of suing in the foreign court. And so whether you are coming under the common law or under statute, the very first thing you have to establish is that the court that pronounced the judgment was properly seized of the matter. And when you are talking about being properly seized of the matter, you are not talking about largely the law of the country where the cause of action occurred. You are talking about two things. One, in international sense, as that court not dragged an unwilling defendant, and that's why the statute will be asking, was he resident there? Did he have a principal place of business there? At common law, they will also extend it to, was he properly served there? Or did he voluntarily submit? And voluntary submission has several meanings, which the statute will then explain. That's the only question that you will ask, as far as whether the court was properly seized. Then after resolving that issue, the other issue is, was there any fraud? Was there a hearing? Was opportunity extended to the judgment debtor to be heard? And that one, don't be confused about it. Don't be confused about it, because you
Hello, Prof. We can't hear you again.
Is it just me, please? I can't hear anything again.
You are not alone, no. I can't hear too.
Edge, you are both not alone. I can't hear too.
Someone should try and notify him.
That's the one.
Class rep, kindly help us do the needful. Class rep, kindly help us do the needful.
Please call Prof.
Today is a special day for us.
Hello, sir.
Who is trying to call me? I excuse myself now. Somebody gave me a very important call.
So
That's
sorry,
why you
sir.
were.
Yeah, sorry, sir. Yeah.
So
Yeah,
as
sorry,
I'm
sir.
saying, familiarize yourself with this subject area very well and understand arguments that are non-starter for anybody who understands the subject. So what are the conditionalities for recognition? I've said you won't find anything there saying you should go into historical inquiry as regards whether the law of the whether the applicable law was properly applied. That's not your business. Your business is was the court's properly seized of jurisdiction in the international sense, and international sense simply means was the judgment debtor resident there? Did he have a principal place of business there? If you are trying to enforce that common law, was he served with the writ while on that territory? Or was there a voluntary submission? That's all the question you ask. I don't know any of this one that you will need the court with the original jurisdiction on the course of action to answer. Do you understand? Then the other requirements are whether there was fraud, whether there was fair hearing, whether the judgment was the final judgment, because you don't enforce interlocutory orders. Which other ones? Which other ones? Which other ones? I'm sure those who presented the thing would have given you the other condition. So if you ask yourself, what are the things that the court is going to satisfy itself with? You will see that none of them require that it should be the court that could have entertained the original cause of action. And so when the statute says High Court means federal or state, the best way to look at it is that what the statute is doing is treating enforcement of judgment as a course of action on its own, because there is a disconnect between the original cause and the judgment. All that the enforcing court is being asked to do is, here is a judgment from USA, here is a judgment from UK, okay? You need to adopt it as a Nigerian judgment in order to give effect to it. So that those type of objections for me, they are neither here nor there, but because the people raising it are usually the senior most among us, and the judges, they don't listen to superior argument, in my own view. They sometimes often give it. They gave it in the case of Access Bank and this their former managing director, against whom judgment was obtained in the UK. The action was originally, the enforcement action was originally started in the State High Court, and Kadide Johnson fell for debate when our respected senior advocate threw a jab at him that the original cause of action related to companies, and that it's only Federal High Court that has jurisdiction in companies. Why are you entertaining an action to enforce a UK judgment when the original cause of action was companies? I felt irritated by a judge succumbing to that type of argument. I felt that everybody does not understand the subject. I'm usually a very humble person, but I just felt that some of the arguments are downright. If I were to assess somebody's script and he gave me that as a reason, I know what I would do to him. But that's what happened. The court declined jurisdiction. Even though the statute said any state high court, any high court is either state or federal. You can come to state high court because the original cause of action was companies and the federal high court that had jurisdiction. Is that the issue before you? The issue before you is a straightforward issue. A judgment has been obtained from a court in UK. The only reason why the judgment creditor is coming here is because the judgment debtor has no asset in UK, but he has asset in Nigeria. He wants you to adopt the judgment as a Nigerian judgment so that he can then take on execution of judgment step that is otherwise qualified to take in Nigeria. In which of these do you really need to bother yourself about the original cause of action being companies so that you'll be able to say, me, as a judge of the state high court, too, I have no jurisdiction in company, go to federal high court. But that's exactly what happened. And I'm sure that there will have been one or two others where something like that will happen. Nothing is beyond what we get from our courts in this subject area, I'm telling you. So that is the first thing. The next thing is, what is the mode of enforcement? Like I told you again, if you want to enforce in Nigeria, you must understand the mode of enforcement in Nigeria. If you want to enforce in Ghana, you must understand the mode of enforcement in Ghana. Because all of the rules in conflict of law, whether jurisdiction, whether law or recognition and enforcement, you are supposed to study the forum zone. So if a person comes to Nigeria and he wants to enforce a judgment he has obtained abroad, what he needs to understand is our own mode. Okay? But fortunately for us, we have Commonwealth culture or model in all of these things. So that, how do you see it? Where you look at a Nigerian statute on enforcement of judgment, you look at a Singaporean statute on the same subject, and word for word, they are saying the same thing. So, but you will find that when the Nigerian judges will interpret their own, wow, they will be far away from what they are doing in Singapore or many of the other countries. That in itself is an indication that something is wrong, that we don't understand this statute, we just have it. So when you are talking about mode of enforcement, not only Nigeria, but in all of the other Commonwealth countries, there are two modes. The first one is suing upon the judgment at common law. You are suing upon the judgment, not upon the cause of action. You are not telling the court to revisit the original cause. But what you are doing is that you are informing the court that a judgment has been given by a country of state Y, a court of state Y. Okay? I have not been able to realize the fruit of the judgment. Because the judgment debtor has assets in Nigeria, I want the Nigerian authority, the Nigerian sovereignty to adopt that judgment so that I can then press further to execute it. That is the reason. So nobody is interested in the story before you're going to court. What we are interested in is the, what do they call it? Those final summary where the court says, this is what I heard. You pay this one to that one, do this one to this. Those are the things we need. So you will just split that judgment and urge the court to adopt it as judgment of the court. That's all you need to do for the court to recognize your judgment at common law. But that method requires you to sue upon the judgment. And in the civil law tradition, they don't sue upon the judgment. What they do is they register the judgment. To register a judgment, there has to be legislative intervention. Okay? So, the first set of registration regime in the Commonwealth are those pieces of legislation
We can't hear you, sir.
Please, can anybody hear?
No.
No.
He might be on a call, so let's just hold on and be patient.
I don't know why this thing mutes itself now. I didn't touch it. Oh, God. Are you hearing me now?
Yes,
Yes,
sir.
Prof.
Very
So
Hello.
when
clearly,
you say
Prof.
this phone is
Very
not even
clearly.
working, safe.
Yes, sir. We
Yes,
can hear you
Prof.
clearly.
So,
Stop. This phone-
I don't even know when the thing mutes
No,
itself. But
Yeah. So you have been talking.
Okay, sir.
I've been talking now. Okay, let me go over it again. I just hope we finish at this rate that I'm going.
Sorry, sir.
I was talking about the difference between a legislation regime and the common law method of suing upon a judgment.
Yes, sir.
Do you understand the common law method as I've presented it?
Yes, sir.
You can recap,
This is
sir.
not even the time to ask you whether you understand. Go and read.
It's me.
Now,
Like I reduced my
the
voice. So it's
legislation
in clash with
regime, like I've told
I
you,
was hearing my voice.
Guys, mute
people
now.
too are also disturbing the class. Can I go on?
Yes, sir.
Yes, sir.
Yes, sir.
Tell your class members if they want us to make progress that they should stop disturbing the class now. So as I'm saying, a legislation regime requires treaty, reciprocity. And when we are talking about reciprocity, it is between your country, that is the country, the forum where you want to register the judgment, and the country where the judgment was given. That is a precondition. And like I'm telling you, the 1922 ordinance recognized that. That is why it created two regimes. I said the first one was automatic. So any member of the Commonwealth where judgment is sought to be enforced should just go ahead and register it if the judgment was obtained from any of the three nations of the UK, Ireland, England, and Scotland. Okay? That's automatic. Then the second regime was not automatic.
Prof, you're muted again, please.
I don't think Prof is muted. I think it's the network because he said it categorically that he's not muting. I think it's a network issue.
I think the network is throwing him in and out of the
Yes,
class.
it's not muting, it's the network.
It's throwing him in and out. He's now muted. He's muted now.
Yes, can I go on?
Yes, Prof.
Yes, sir.
Yes, Prof.
So the regime of
Prof, sir, you just on. Prof just unmute himself now.
We can't hear you, sir. You're
I
muted.
think it's a network. I think it's a network that is causing all those mutes.
okay. You can hear me now.
Yes, sir.
Yes, sir.
Yes, sir.
Okay, so I think I've done all the explanation on the two regimes and all of that. So that was the 1922 ordinance, which provided for those two regimes
We can no
based
longer hear
on.
you, sir. I believe it's the network that is affecting you.
Can you hear me now?
Yes,
Yes, sir.
Yes, sir.
Yes, sir.
So that was the 1922 ordinance. So, and it was the first time, it was the first time that UK will do anything like registration with another country. Okay? But you know that UK did not consider our colonies as separate countries. It considered them to be members of the same family and all of that. Okay? Now, English businessmen, they do more of their business with surrounding countries like Italy, France, Germany. They do it with nationals of surrounding countries. And so these registration regime that is created as between UK and other Commonwealth country will not affect many of their transactions or relationship with fellow Europeans. In other words, whereas it was possible to automatically register in Nigeria or Ghana, judgment that they have obtained in their country against a Nigerian or Ghanaian judgment debtor, they wouldn't expect that to happen to them in Italy or Germany or whatever. And the businessmen will do more of their business with nationals of those countries. Why would they not be able to do so? Like I have told you, a registration regime is preceded by agreement between two countries. So if UK had not entered into any agreement with Italy or Germany or whatever, the registration regime cannot happen with regard to UK judgment if they want to give effect to it in Italy or France or Germany. Okay? But the UK citizens, the UK businessmen, they reason that they are at a disadvantage. Why are they at a disadvantage? They are at a disadvantage because the common law method of suing upon judgment does not discriminate. It doesn't want to know where you have obtained the judgment. So an Italian judgment creditor that has obtained judgment against an Englishman in Italy would easily be able to come and sue upon that judgment in England when once all of the requirements, the requirement of jurisdiction in international sense, there was no fraud, there was fair hearing, it is a final judgment, and what have you. Once all of those have been met, the English court will not inquire about the original cause of action. It will treat the judgment as res judicata and go on to enforce it. So the English people felt that they are shortchanged because whereas the Italian will be able to sue upon his Italian judgment, they will not be able to do so. They will not be able to sue upon their English judgment in Italy. And the Italian system will not permit them to register it because there was no arrangement between Italy and the United Kingdom. So they protested. They agitated that this regime that has been established as between us and the Commonwealth, we also need it. But like I told you, a legislation regime is reciprocity or treaty based. It meant that the government of the United Kingdom will have to go into treaties with all of those surrounding countries. And it is those treaties that would now be domesticated in order to give the English businessman the opportunity to register a UK judgment in Italy or Germany or whatever. So that was what gave rise to another law, another statute in 1933, another UK statute in 1933, whose main motive was to extend the legislation regime beyond the Commonwealth so that British citizens would be able to register UK judgment in surrounding European countries. Okay? And because what is chose for the goose is chose for the gander, the British authority encouraged our Commonwealth countries to also adopt the same policy. And it was that 1933 policy that Nigeria eventually adopted in what is called Foreign Judgment in bracket Reciprocal Enforcement Act, which was enacted in 1960, came into force in February 1961, and has since remained an item on all subsequent laws of the Federation. Presently, it is Cap F35. Presently, it is Cap F35 LFN 2004. Okay? So, what then are the issues? The very first thing we know by our knowledge of this subject area is that whether it is Cap F35 or Cap 175 of 1958, a legislation regime is a treaty arrangement. It is preceded by a treaty arrangement. Okay? And so you can't be talking about registering a judgment from any country without first finding out whether your country had entered into a treaty with them. That is why we often tell lawyers that you have abandoned the common law method without any good reason. Your abandoning the common law method is a display of lack of understanding, because you can't go to a court, say you want to obtain judgment, you want to register judgment from US, for example. You must first find out whether there is a treaty between US and Nigeria. And those treaties will usually be based on reciprocity. And the statutes themselves, they say so clearly. So if you understand that, it becomes very easy for you to construe Section 3, the problematic Section 3 that required the minister to publish an order, and that the state from where judgment was obtained should be included in that order before you can proceed under Cap F35. The reason is very simple. It's very, very simple. We said we need treaty. And both in Nigeria and the UK, treaties do not automatically apply internally. You will need to go through a process as prescribed by Section 12 of our Constitution, okay, known as, we call it domestication. So it would then have meant that for every country whose judgment you want to allow to be registered, the executive may be represented by the Minister of Foreign Affairs or Attorney General, would have to enter into a treaty with them so that they offer us reciprocal arrangement. That treaty, the executive will have to present it in the National Assembly for domestication. And it would have to be domesticated. That would have to be the condition for enforcing, by way of direct registration, judgment obtained from any country under Cap F35. But the procedure can be shortened. And that's what Section 3 has done. What Section 3 has done is to treat the F35 statute as the enabling legislation. So you don't have to go back to the National Assembly to domesticate each treaty you make. You don't have to go back. But somebody, a member of the executive, will know which treaties have been made, and he will then be obliged to publish it in the Gazette by way of order. So once he does that, the name of a country appears in that Gazette, in that is order, is a confirmation that the executive has done a treaty with that country. There is a reciprocal arrangement between Nigeria and that country. And instead of submitting the treaty to the National Assembly to enact a U.S. judgment enforcement statute, the publication of that order will suffice. So you see, if you now understand this very clearly, you will see how irritated you will be if somebody is telling you that you cannot use F35 to enforce the judgment obtained from any country before the minister makes the order. It's so elementary. The minister has to first make that order. There's no way through it. Now, if you study the cases, you will see that our bar and bench is thoroughly confused. Thoroughly, I say it with due respect. Thoroughly, we are thoroughly confused. The first issue is you find a lawyer. He will go to court. He will apply to register a judgment, a foreign judgment, under both 1922 ordinance and Cap F35. The regime of the two statutes are fundamentally different. Fundamentally different. Read any basic text, read my article, you will see at least 5 or 6 differences between the regime of the two. The first one is mandatory, the other one is alternative. So if a country's name, if an order is published today, and Guyana, for example, is listed as a country whose judgment Nigerian court will register, you no longer can use common law method for judgment from Guyana. But the 1922 ordinance only offers an alternative. You still have the option of doing your common law thing. And the advantage of the common law method is timeline. It is the same timeline for enforcement of local judgment that you have for enforcement of foreign judgment at common law. So you want to go to Lagos to enforce the judgment you obtain from UK. The limitation statute of Lagos gives you 12 years to enforce the judgment you obtain from Nigeria. It is the same 12 years you have to enforce the judgment you obtain from UK if you are suing upon it at common law. If it is Rivers, where their own limitation statute gives 10 years, it is the same 10 years you have to sue upon the UK judgment in Rivers. No difference between local and the foreign judgment for the purpose of enforcement in Nigeria at common law. But if you are doing under statute, the two statutes presented two different rules. The 1922 ordinance says you must apply to register the judgment within 12 months. The CAP F35 permits you up to 6 years. The 1922 ordinance says unless the court gives you leave. But you know that if you are gone into second or third year after the judgment was obtained, it will be very difficult for court in the judicial and judicial exercise of discretion to grant you such a leave. So time is very important. There are other differences, but the major one from the perspective of methodology is that if you understand the 1922 ordinance very well, Cap 175, it requires you to face your first roadblock at the point of petition, at the point that you are petitioning to register the judgment. So you put the other party on notice, and the other party, if he has any reason why the judgment should not be recognized, that is the time you will fight it out. So the task of registering judgments under Cap 175 begins from your very first step, because you will have to put the other party on notice. On the other hand, under Cap F35, it's an administrative thing. Cap F35 permits the judgment to be registered the moment you present a certified true copy of it and do some administrative things. But it is after the registration that the judgment debtor will be put on notice. It is at that point that the judgment debtor will now apply to set aside the registration. So you see the difference in the procedure. The 1922 ordinance would permit you, as you are filing your petition, to register the so-called Commonwealth countries' judgment, to put the judgment debtor on notice, so that he will have the option to object. Cap F35 will readily register once you have produced a certified true copy and sworn that the judgment sum has not been paid or has not been fully paid. The court will register it, but that is an administrative thing. The court will then put the other party on notice, and the other party will then come and say, set aside the registration you have done. Compared to the 1922 ordinance, the court will not even register until it has listened to the other party. We are lawyers. You can see the difference between the two regimes. They are not the same. Okay? But the one that is most important the one that is most important is that there is no automatic transition. What did I say? There is no automatic transition. And that is the area where our courts are making elementary errors. There is no automatic transition from being a country whose judgment is registrable under 1922 ordinance to a country whose judgment is registrable under F-35. The same ministerial order is required. So the minister is required to publish an order, even if it is a Commonwealth country that wants to transit from the Commonwealth arrangement under 1922 ordinance to the worldwide arrangement under CAP F-35. If he doesn't make that order, there is nothing like when we were students, it used to be suggested by our professor that at least if the judgment was obtained from Commonwealth. Are you hearing me?
Yes, sir.
The proposal used to be made that at least if the judgment was obtained from a Commonwealth country, it should be assumed that it has automatically transited. But we now know very well that that was a wrong submission. The minister would have to make his order under Section 3 and include the name of the so-called Commonwealth country there before you can say it has transited to the CAP F-35 regime. And you know what? Go to Section 9, subsection 2 of CAP F-35. It says, the moment that is done, you will cease to have the right to register the judgment of that country under the 1922 ordinance again. So I ask you, why will you as a lawyer go to court and say you are relying cumulatively on the 1922 ordinance or CAP F-35? It's an elementary error. You cannot, it's not possible. The statute itself says so. You will not be able to enjoy CAP F-35 regime in respect of judgment that 1922 ordinance qualifies you to register until the minister publishes the order. And the moment he publishes the order, you will cease to have a right either to continue under common law or continue under 1922 ordinance. You must proceed under CAP F-35. So on what basis then are you going to have the two statutes apply cumulatively? What do you find Nigerian lawyers and judges do? Somebody wants to register a judgment. He will then be relying on both the ordinance and CAP F-35. It's a basic error. In the light of Section 9 of Section 2, and when you read under Section 3 very well, it is not possible at any point in time for you to be able to enjoy the best of both legislation. Go and read the Nigerian judgment. I took my time to read them. I listened to lawyers' arguments, and I'm shocked. The level of ignorance in this area is, I don't know which one we are exhibiting more ignorance in. Is it in respect of jurisdiction? Is it in respect of jurisdictional immunity? Or is it in respect of foreign judgment? But I think the one of foreign judgment is particularly calamitous because unlike the other ones, we are usually citing statutes that have replica in Ghana, in Singapore, and all of that. And our court will come with judgment that runs contrary to a Commonwealth practice. What is our problem? Then I can't go over everything. Then you have all this laughable error of relying on Section 10A to permit registration under CAP F-35. What you don't know, you don't know. That's just it. What you don't know, you don't know. It was in Macaulay and Ll.M of Australia that the issue first arose. In Macaulay and Ll.M of Australia, the UK judgment that was sought to be registered had already was given some 2-3 years ago. And you know that whereas registration under the 1922 ordinance was automatic or is automatic, you must bring your petition within 12 months. Within 12 months of the judgment. So 3 years after the judgment was given, you can't use the 1922 ordinance. Now, counsel had the option of suing upon the judgment because the common law method would have permitted you to enforce within the same 12 years that you have if it's a local judgment. So the simple thing would have been sue upon the judgment now. You can't use 1922 ordinance again. Sue upon the judgment. But what did the man do? He then sought to register under Cap F35. And so all of the arguments were on registrability of the judgment under Cap F35. And the court agreed with the objecting counsel that no, you cannot register because the minister is yet to publish an order. In fact, the Supreme Court said, as far as it is concerned, Cap 35 was into it. That's the language of the Supreme Court itself. I read the judgment, was into it. A very fine word. A very, very fine word. When you say something is into it, it means something still has to be done in order to give effect to it. Okay? Nobody asked the Supreme Court an alternative question. Nobody. I don't think anybody asked the Supreme Court the alternative question. Okay, can I use Section 10A? If somebody were to ask me that question, if I was a member of the panel of the Supreme Court, and somebody were to ask me that question, I would laugh. You know why I would laugh? I will laugh because from what I have told you now, you can combine regimes. Until the minister publishes an order including UK, you cannot register UK judgment under Cap F35. When he does it, according to Section 9 of Section 2, you must stop registering UK judgment under Ordinance 1922. So in what way, when the minister has not published an order, can you use Section 10A to say, you see, I can also do it? But the question was not asked, and the judges of their own now said, you see, if he had come within 12 months, I hope you are listening to me.
Yes,
sir.
sir.
The
Yes,
Supreme
sir, yeah.
Court, by way of obiter, really, because the issue did not arise, the Supreme Court said, if the judgment creditor had come within 12 months of the UK judgment and had sought to register under Cap 35, he would have used Section 10A. Definitely, they didn't look at the entire issues. They didn't look at the entire issues. If they had looked at the whole thing, the first thing they would have known is that so if they had looked at the entire issues, the first thing they would have noticed is that there is no cumulation. You cannot cumulate the two statutes. The second thing they would have noticed is that If the minister did not publish an order, including a country's name, CAP F35 cannot be used to register that country. So how can you put the cat before the horse? It's not possible. So the moment the Supreme Court said CAP F35 was into it for purpose of registering, in fact, any judgment, that ended the matter. Trying to use Section 10A to say, however, is a betrayal of understanding. It's a demonstration of lack of understanding of the subject, with due respect to everyone. Okay? You are basically putting the cart before the horse. If the minister did not make an order, you can never register any judgment under CAP F35. Section 10A, I've explained in my write-up what the purpose is a transition provision that can only be relevant after the order has been made. But before its commencement, you know, the minister can make an order. He can say, okay, as from the minister can publish in the Gazette and give a date when the Gazette will become operational. He can publish an order now, including, say, Guyana, and say with effect from 1st of January 2026. The question is, if the judgment was obtained in August 2025, somebody will be able to raise the question, well, here in Nigeria, Guyana's judgment became registrable directly when the Gazette came into effect in 1st of January 2026. So you obtain your judgment before 1st of January 2026, it will not be covered. That's what Section 10A is saying. That no, it is quite possible if the order has been made and the order has come into force to extend the registrable judgment to some 12 months before the date of coming into operation of the order. That is the way all of the other Commonwealth countries are construing their own equivalent of Section 10A. But what do we have? Plethora of cases where Supreme Court keeps goofing because our senior lawyers keep misleading them. Somebody went to court very recently seeking an order to compel the Attorney General to do the needful to publish that order. That is the correct thing to do. If the Attorney General does not publish that order, CAP F35 for all the things that are proposed remains into it. No Section 10A can save it. But here we are. Here we are. We don't apply ourselves to the black and white of the law. We just guru. I remember telling another class that, well, the judges, you don't blame them. They have to give judgment. They have to give judgment. Sometimes you don't know the difference between them and those who preside over school debates. There has to be a winner. And so, if garbage is coming from both sides, you must use one formula to say you accepted the argument of one person or the other. But we are all far away from what our statute is saying. And we don't need to travel far. All we need to do is just, this statute is not peculiar to us alone. How are the other countries interpreting it? Look at what the Court of Appeal decided in the case of Teleglobe, whatever, and 21st century. That's a very laughable decision. Very, very laughable. Laughable on two accounts. In the first instance, the judgment was a judgment from the United States. We can even understand if it's a judgment obtained from UK. We can say that, well, we have one registration regime with UK, which is the 1922 ordinance. And the question is whether it has automatically transited into CAPF 35. But every Commonwealth country knows that you don't do reciprocity with US on enforcement of foreign judgment, because US will never allow your country to register our own judgment in our own country. Their own only method is swing upon the judgment. So anybody who knows this area would have known that US is no go area for registration. But that was exactly what was done. The cartel had brought the application under CAPF 35. They had brought it under CAPF 35. Then there were also the issue of whether the Nigerian judgment debtor was properly, whether the US courts were properly seized of jurisdiction over the Nigerian judgment debtor. The facts were that he was served by way of assumed jurisdiction type of thing. Leave was obtained from the US court, and based on that leave, he was served in Nigeria. But he objected. He objected. And the US court ruled out his objection and went ahead to give judgment. So when the judgment was sought to be enforced, he raised the same issue. You know what the court said? The court said, please shut that door. Ẹ bá mi tilẹ̀kùn. Mo tún sá fún yín, ẹ tún ti sílẹ̀kùn sílẹ̀. Ìwọ́dà tilẹ̀kùn yẹn. So when the Nigerian judgment debtor challenged the enforceability of the judgment on the basis of jurisdiction, the judge simply said, look, the issue you are raising has been resolved by the US court and we cannot sit on appeal over US judgment. That is wrong. That is wrong. Even is appearing to, the judgment creditor is appearing to enforce the US judgment. And the Nigerian authority should have our own opinion on whether the judgment is registrable or not. You cannot say that by looking at the issue of, and if the court had really look at the issue demand is, the court would have come to the same conclusion as the same court came in the case of Access Bank PLC and Gazan allowed case, which is that if you didn't meet the requirement of territorial jurisdiction, you are not able to show that you had a right over the judgment debtor as understood by our own rules, then the judgment is not enforceable. But the court said, but I said that was a laughable judgment, because in the very first instance, no other Commonwealth country would use a registration regime for a US judgment. Because the first question, which is reciprocity, can never be met. Because we know as a rule that US does not permit registration of foreign judgment in our country. So you don't need to check whether the minister has made an order. You know that you are talking about a territory whose position on the matter is very clear. So the only way you can enforce a US judgment in Nigeria is by suing upon it. But the council registered it successfully under CAPF 35. They couldn't even have registered it under 1922 anyway. So our bar and bench will need to understand that it is either you register under 1922 ordinance or you register under CAP F35 when it enters into force. Because something still has to be done before you can even register any judgment under CAP F35. I'm saying this notwithstanding that we have plethora of Supreme Court cases that have adopted the obiter of Macaulay and Ll.M of Australia as authority. You can read Professor Olawoyin's article also. Notwithstanding that, an error does not become correct simply because it is repeated. It's an error, and it's a basic error. It's not an error that you struggle to convince anybody why it's an error. It's an elementary error. You see, when in Macaulay and Ll.M of Australia, the argument was on whether the 1922 ordinance was extant or not. The Supreme Court gave a fine judgment that it is those who compile laws of documentation that excluded it, and the compilation cannot be a repealing activity. And so you do not have to say, because F35 is repeated in subsequent compilation, and Cap 175 is not repeated. Therefore, Cap 175 and 620. Fine argument. But do you know the most basic argument that would have been put up? The most basic argument that would have been put up is that Cap F35 and Ordinance 1922 are governing different things. One cannot even repeal the other. They are both to coexist, because if the minister publishes an order today registering Guyana, indicating Guyana as a country whose judgment will be enforceable, you want to go and register judgment from Guyana, you can only do it under F35. How would Ordinance 22 be repealed for you to be able to proceed under F35 in that circumstance? They are not cumulative. They are governing different scenarios. They are governing different countries. The compilers did not understand. The Supreme Court too did not exhibit that they understood that. So they went on to look at a different question, which is whether the non-repetition of a chapter in subsequent compilation amount to a repeat. They gave the correct answer, but that was not the issue before them. The issue before them is 1922 ordinance and Cap F35. Are they necessarily cumulative? Or is Cap F35 meant to replace 1922 ordinance? The answer is no. They cover different scenarios, and the two, one will not prevent the other from existence. And it is that lack of understanding of that basic point that will make counsel go to court and say, if you cannot give me what I want under Section 5 of the 1922 ordinance, what of Section 10 of the Cap F35? In the very first instance, you have to come under either of the two. You can't come under the two together. So, hello, are you hearing me?
Yes, sir.
Yes, sir.
I think we should stop enforcement of foreign judgment on that note. Okay?
Thank you,
I've
sir.
asked questions around these issues. So go and read very well. The questions will be technical, but if you know them, they will be very elementary. So what else are you going to read? Firstly, go and get my article in the Appellate Review. I have an article in the Appellate Review where I think I criticize the judgment of the Supreme Court in Matilda, Abiodun Dairu, and Union Bank. Okay? It's not my best article on that judgment. My best article on that judgment was eventually not published. But if I am able to lay my hand on the draft, I can send it to you. Okay? So it is common for our courts to say one matter is one state matter, another state cannot entertain it. These are that elementary demonstration of lack of understanding. How do you say that a matter is a state matter? Is it because the facts occurred there? Is it because the defendant resides there? Do you understand? Or is it because the state, by its own sovereign act, has demonstrated interest? When you are talking about a matter being a particular country or a particular state matter, to somebody who understands conflict of laws, he will just laugh. There's nothing like that. If you want to sue in Nigeria, you don't have an international guide on whether Nigeria has jurisdiction or not. You will have to examine Nigerian choice of jurisdiction rule. It is what Nigerian choice of jurisdiction rule permits Nigerian court to entertain that you call a Nigerian matter. In the same way, in the interstate level, it is the state that the party wants to sue, whose jurisdiction rule we are going to consult to be able to say whether the matter is a matter or not. You will find that in that case, the court was busy telling us that Nigeria is a federation and Nigeria was divided into 36, 37 different territories. You cannot bring the matter of one territory to another. It's begging the question. It's not giving any answer. The real question is, what is the basis upon which a state will assert interest in the matter? And you don't have one answer or one rule governing all. The state can assert interest in the matter because a resident, somebody residing in a territory, he is a party. A state can assert interest in a matter because it occurred in their state. So in a case like Dairo and Union Bank, Dairo's house was in, I think, Iju or somewhere in Ogun State. One of those places that when you are in them, you will not know that you have left Lagos. If you go to Isheri North, they will tell you that these houses are in Ogun State. Those ones are in Lagos. So I think it happened in that case that a defamatory auction notice was published on Dairo's property in Ogun State. But Dairo did not sue the bank in Ogun. Dairo came to Lagos, sued the bank in Lagos, where Union Bank has our headquarters. And lo and behold, all of the Nigerian courts, from lower court to, they listened to argument that that was an Ogun matter. It was an Ogun matter. And so Lagos didn't have jurisdiction. What makes it an Ogun matter? In their own view, because the publication was done in Ogun. Okay. Why is Lagos not interested? Why will Lagos not be interested? Because Union Bank is resident in Lagos. The elementary errors are there to see. There's a difference between choice of law and choice of jurisdiction. For purpose of jurisdiction, you examine the choice of jurisdiction rule of the forum where you want to litigate. If it does permit you, then everybody in the whole world would say that you have filed action in the right place. What does Lagos State choice of judicial rule, what does it say? Lagos State choice of judicial rule is section 9 and 10 of the High Court law. Okay? Section 9 and 10 of the High Court law. What does it say? It says you should adopt the same rule as the English court. And the English court rule is writ rule. So it doesn't matter where the fact that occurred. If it is possible to serve the writ on the defendant within the territory of Lagos, Lagos has already asserted jurisdiction. That is the point you ought to be telling us, showing us what part of the Constitution says that is wrong. Not using elementary logic to say Nigeria is a federation, so you will know you are in Ogun State when you are in Ogere. It doesn't answer any question. It does not answer any question. So you cannot say because the event occurred in Ogun, that exclusively made the matter an Ogun matter. There are other bases upon which Lagos can assert interest. And they are not unconstitutional. There's nowhere in that same constitution that you are looking at that you will say simply because the matter occurred in Ogun, Lagos can never assert any interest. So it's clear lack of understanding. And anybody who understands the subject will know that there are statutes on the matter. There are case laws on the matter that if counsel are presented to the Supreme Court, they would not have made the error that they made. So look at how I look at all of these cases. Because you see, this subject is under challenge. If we don't answer all these wrong assumptions, then you can read the case of, there's a case decided by Abiru, now GSC, when he was in the Court of Appeal, Kaduna. Okay, I discussed it in that my appellate review article. Very interesting case. Because Abiru's background was conflict of laws, he was able to deal with the issue in a way that you will see contradicts what the Supreme Court is saying, but you will sense the correctness the moment you start reading it. So those are the issues. Okay? Read discretionary jurisdiction. Read the alternative reliefs when you want the court to decline jurisdiction. It's either you are bringing an application for stay, not preliminary objection, or you are bringing what is called anti-suit injunction. Okay? Read whoever, whatever seminars you presented on that. But you can also read my book. I think I briefly discussed it. I don't think satisfactorily because I think maybe I've had 1 or 2 articles on it and all of that. So read that. I will ask you product liability. That is the only law question I will ask you. I won't ask you contract. I won't ask you trust. I won't ask you cooperation. Can't you clap for me that I'm helping you?
Prof, we appreciate, sir.
Go
Prof.
and
We
read,
are
Thank you, sir.
grateful,
Thank
sir.
you, sir. Thank
We
you
are
so
grateful.
much, Prof.
go
Thank
Thank you,
you.
Prof.
go and read product liability, especially a convention. And when you are reading it, I don't want long story. I only want the choice of law aspect. So you read Article 4, 5, I think 6, up to 9. Yeah? Remember I told you that the Hague Convention introduced a scheme of combination or permutation that the country whose law you apply must combine either being the place of injury together with being the place of residence of the defendant. One simple contact is just not enough to determine applicable law. The country whose law you apply must combine multiple contacts. That's what we call permutation or combination. Okay? So read that scheme very well. Okay? We are not interested in jurisdictional issue. Okay? We are interested in how do you determine the law that will govern a product liability, a cross-border product liability dispute, so that if a product manufactured in US, bought in South Africa, causes injury in Ghana to a person resident in Nigeria, and the action is before the Nigerian High Court, how do you arrive at applicable law? You see the multiple contacts here, okay? These multiple contacts might have different standards, okay? And there's a possibility that the manufacturer in US was only concerned with the US environment. So you can say, I didn't expect my product to get to Ghana. How can you hold me responsible when I did not have Ghanaian weather in mind when I was manufacturing? Those of us who buy cars, okay? Some countries' problem is cold weather. So what they put in their car will be heaters. But if the car is used, Lamida Aboko Etije, lower voice there now. Most often here, then disturb me. So, as I'm saying, if the car is now used in West Africa, our own problem is heat. So if you are complaining about anything that has to do specifically with those things, the manufacturer in US can tell you, how can you hold me responsible? How can you apply your own standard to judge me? Because I never intended that my car will extend to your country and all of that. Those are issues that between Articles 4 and 9 of that convention were treated. You remember, of course, that Nigeria never ratified any convention. Our performance in the area of private international law is, if there's anything less than 0, that's what it is. I don't think we have ratified any significant treaty in the subject area. But just for understanding sake, you can look at how useful that convention is and whether it has solved the problem of cross-border product liability. Okay? What else? Jurisdictional immunity. We look at cases. Yes, go and read apart from my chapter 6, I think somebody presented article on immunity from suit of international organizations. I don't know whether that group. Hello? Hello?
Hello, sir.
Hello, sir.
I don't know whether the group that presented on jurisdictional immunity of international organization, I don't know whether they discuss the basic error of our court. The basic error of our court in that area is that they don't even appreciate that all these restrictive immunity regime does not apply when the immune entity is an international organization. When the immune entity is an international organization, the issue usually is whether our own internal statute, whether the treaty establishing it or our headquarters agreement, whatever, has internal mechanism for remedy. If it does, the usual thing is for member countries or host country to recognize that a litigant will exhaust those remedies. But if they do not have, what the European countries, what their courts have said is that, well, we will consider overriding the right to be heard over respect to international organization. So our court will entertain cases against international organization. That is the principle. You look at the African Insurance Corporation cases, you don't see anybody understanding that that is the principle. You see them treating international organizations as if they are state corporations. Go read all of them, read all of the cases, from Fantaye to JDP Construction to AIM Consultant. You see that that particular aspect is not known or is not shown to be understood. So that is one thing. Then state immunity, we don't have any legislation on the subject. Our courts are struggling with understanding the distinction between state immunity and diplomatic immunity. Then they are struggling with understanding on what basis will you adopt the restrictive immunity regime. You find them, for example, in Oduwalogba, you find the court saying, well, if you want to use Trented and CBN to meet, Trented and CBN has to do with contract, not thought. You find Crema Italo, you find the judge saying that a contract to construct an embassy is not a commercial transaction. All of these betray a clear lack of understanding of the restrictive regime. Most importantly, they betray the fact that customary international law should be our source of law in that area. Publicists will tell you that whereas you will have to domesticate treaties. There's nothing to domesticate about international customary law. International customary law is a mirror of accepted usage. To quote our court in Owoyin and Omotosho, is a mirror of accepted usage. So the moment you see that something has become the practice of the world, your country not having expressed itself as an objector to that practice, your court is qualified to apply it in the case before her. Your court should not even wait for the Supreme Court to overrule itself. That is the lesson we learned from Lord Dennis' judgment in that case now, Trentex and CPN. Nigeria was at the receiving end in that case, but we cannot learn from what we have received. We still allow ourselves to be deluded that immunity remains absolute. So you look at all of those areas and be able to tell us what is basically wrong with our judgments on recognition and enforcement. What else have I not said? What else have I not said? Read chapter 5 of my book, especially provisions of the Sheriff and Civil Process Act, sections 96, 97, those requiring special endorsement. This special endorsement that is required, does it apply to writs of every high court? Why should it apply to writ of the Federal High Court? Why? Why should it not? Okay? There's a case I discussed where I was disagreeing with the Supreme Court judgment. Do you think I was right? If you look at the definition of court for purpose of chapter 7, does it include Federal High Court? If part 7 of the Sheriff and Civil Process Act is trying to solve problem that has to do with crossing borders, when you file in Oyo High Court and you have to serve in Lagos, should it apply to the Federal High Court where there is only one Federal High Court? Shouldn't that be a matter to be governed by their own local venue rule? So when the Federal High Court local venue rule says you need to obtain leave before you serve writ of Lagos High Court at Ijebu-Ode or Ibadan, why do you also need to specially endorse under the Sheriff and Civil Process Act? In the case that I discussed, you find that the Supreme Court said, yes, they will also still need to specially endorse. And I said the Supreme Court was wrong. They were wrong because Sheriff and Civil Process Act, the whole of chapter 7, is concerned with interstate. You can't be talking about interstate when you obtain a lead from a Federal High Court, because there's only one Federal High Court and it belongs to the whole of Nigeria. So I think I can just wish you best of luck. So I've told you things to read. I have an article where I criticize the Nigerian judgment on the immunity of African Insurance Corporation. It's published in Journal of Africa and International Law, a journal that is published in some of the East African, one of the East African universities. Okay? So look for it. But if you trouble me, I can. Well, the first thing I will do, I will give you the citation of that article. That is on the incorrectness of our court attitude treating international organizations as if they are state corporations. Okay? Even if the outcome, the final judgment might be pleasant, the mere fact that you miss the principle from the onset, we should not close our eyes to it. Receiving immunity does not apply when you are talking about immunity of international organizations from suit in Nigeria. The different rules are laid out in that article, and you should understand. And that will basically knock out all the decisions of the African Insurance Corporation decisions. Okay? Even if we love the outcome of AIM Consultant or JDP Consulting, we cannot ignore the fact that wrong formula was applied. Okay? So I will give you the citation of the articles that you should go and look at. I will look at my CV and give you those citations. And if you cannot find them, if you trouble me enough, I can make them available to you. Let me go and say my prayers. I've done my best for you. I wish you best of luck.
Thank you so much,
Prof.
Prof.
Thank you,
Amen.
Prof.
Thank you,
Thank you
Prof.
so much,
I
Prof.
really appreciate it,
Bless
sir.
you.
Thank you, Prof.
Thank you.
Yeah, we are grateful, Prof. We are grateful, sir.
Thank you, sir.
If anyone who was able to get down the areas of concentration should please post for us, please. Thank you.
No, kò má tà. Ṣé wọ́n ti ṣe tán? Wọ́n ti ṣe tán. Wọ́n ti ṣe tán àbí? Ẹ ti kúrò jù. Ẹ̀mí ò rí ni, ó ti block ẹ̀yìn. Kò má tà. Ẹ kúrò bẹ́ẹ̀ ni, kò má tà. Tó bá yá kúrò. I don't know why you don't like it. You see, you have been using it. But I didn't see it. This thing, I think it's no,